Hello, we're Sara, Hunton and Francis Wilkinson, and we're barristers at Field Court Chambers, and we wrote the first edition of Costs in Family Proceedings, and now the second edition is coming out. What are the difficulties in making an application for wasted costs?
Well, it's not an application that family practitioners often make, and as a result, it's not an application that family judges often hear. And the procedure is a little bit complicated, and it is easy to get it wrong. There's a multi-stage approach to making such an application. Wasted costs are ordered when a legal representative, be it a barrister or solicitor, causes a party to incur costs because of their act or omission which is deemed to be improper, unreasonable or negligent. And as a result of that, the court considers it's reasonable for the costs of the party to be covered in whole or in part. The application is made under Part 18, or it can be made orally at a hearing, and the applicant sets out what they allege has happened or not happened and the costs that they're claiming. At that first stage, the court will make a decision as to whether or not there is a prima facie case to be answered. And at that point, there is no need for the legal representative to be involved or to incur any costs themselves, because unless the court decides it needs to proceed, then it will end before they become involved. So initially, the burden of proof is upon the applicant, but if the court decides there's a prima facie case, which looks as though it needs to be answered, then the burden shifts to the legal representative, and the standard of proof will be the balance of probabilities. The legal representative clearly at this point must be given an opportunity to show cause why the order must not be made. And the court, the procedure for doing this is under Part 46, and the practice direction sets out that the court has discretion in two areas. Firstly, they must be satisfied that there's evidence which, if unanswered, would be most likely to lead to a wasted costs order. And then the second area of their discretion is that they must determine that wasted cost proceedings are justified given the likely costs involved, and this is the proportionality element of the test. The practice direction sets out the three rules which I've mentioned briefly that the test for making a wasted costs order. And first is an act or an omission which is unreasonable, improper or negligent. And secondly, that must cause the party to incur costs unnecessarily. And then the final point is that it's just in all the circumstances to compensate the party for some or all of the costs that have been incurred.